Konnichiwa from my side. Before I start, I would like to express my gratitude to First Secretary Monaco and Mr. Luca Escoffier, who made it possible that we present the latest developments in the European IP law here today, and to all the helping hands who made this seminar possible. Thank you very much. To correspond with the European concept of this today's seminar, I want to present, well, maybe not the latest development in IP law in Europe, but certainly an important one. And I learned that Japan is at the verge of adopting a similar law, so it might be of interest for you to learn something about inspection claims. And for the European notion, I would like to give you a little comparison between the German system and how the law works in France. So, what is the factual scenario? Just imagine that a patent holder, patentee, assumes that his patent is infringed, and let's say it is infringed in Germany, and it is infringed by the same potential infringer in France as well. And he faces the situation that he cannot entirely prove this infringement because he has no access to the infringing embodiment. For example, a machine inside the premises, inside the plant of the potential infringer. So what can we do? First, let me have a quick look at the legal framework in Europe. Already some years ago, there was another European directive adopted concerning the enforcement of intellectual property rights, and this directive contains provisions regarding inspection claims, especially, and I want to focus on that on Article 7. Article 7 basically says that there are legal measures to preserve evidence or to obtain documents and subject to confidentiality, protection, preservation measures, and this legal tool shall allow the description or the taking of samples of the potential infringing embodiment, and all of this without giving prior notice to the opponent. In fact, this directive, or let's say the French saisie contrefaçon, was actually kind of a role model for this directive, and as a consequence, a role model for the national adaptations and transpositions of this directive. So first of all, let us see how it works in Germany. In Germany, this directive was implemented in a specific section of the patent law, in section 143 of the German Patent Act. And this section requires that if there is a sufficient likelihood of a patent infringement, then the plaintiff has the right or has a claim for production of a document or for inspection, provided that this measure is necessary and not disproportionate. And this can be done by way of a preliminary injunction, and, well, as the directive already provided, without prior hearing. And again, of course, the court has to establish measures to preserve a potential trade secret of the defendant. In Germany, the Düsseldorf court developed a procedure how to actually perform this kind of inspection in terms of a legal procedure. The Düsseldorf courts developed this even before the directive was adopted and transposed, but the so-called Düsseldorf practice survived the implementation into national law, and it's still good law in Germany. And this is how it works. First of all, the plaintiff approaches the court with a motion for an inspection order. The plaintiff has to show sufficient likelihood of a potential patent infringement, whereas the threshold for this likelihood is not very high. This motion is presented to the court, and if all requirements are met, the court will issue a so-called evidence preservation order, which basically appoints a court expert. This court expert shall be entitled and gets the assignment to inspect the infringing product and to issue a report. And the second column of this Düsseldorf procedure is a so-called, it's a preliminary injunction actually, which is flanking this evidence preservation order, and which orders the defendant to tolerate the inspection and to refrain from modifying or altering the item to be inspected. And this is all done without notice to the defendant. This is simply because the moment of surprise is very important. The defendant should not know about what is approaching him at this stage of time. Very important in that the order that is to be issued contains all the measures that the expert is allowed to do, or by the other way around, the defendant has to tolerate. You have to be very careful at this point of time, and you have to put all measures necessary or potentially necessary into the order, otherwise the defendant does not have to tolerate it, and you have no chance to actually perform all the measures required during the inspection. I list in this slide, and you have it in your handout, examples of those measures, which I don't want to read out here aloud. Also, the submission of documents or the surrender of data could be subject to this order. As long as it is a submission to or surrender to the court expert, this is still part of the description of the inspection and not surrender of documents directly to the plaintiff. So once the inspection order is issued, it has to be served upon the defendant. And this is done by a court bailiff who appears in front of the premises of the defendant together with the appointed court expert. What is special in the German proceedings is that the court expert is accompanied by a legal counsel of the plaintiff. He shall observe that the court expert is not hampered or otherwise the inspection obstructed by the defendant. The plaintiff's counsel, however, is bound to secrecy and confidentiality, even towards his own client. So he at this point of time, he must not say anything about the inspection to his own client. So once the expert and the attorney enters the premises, the inspection starts, and the expert issues a report which is handed to the court first. The court will forward the report to the defendant, of course, and his legal counsel, but also to the plaintiff's legal counsel alone, only, not to the plaintiff yet. At this point of time, the defendant has the possibility to object trade secrets, and object that some of his confidential information has been discovered during the inspection and is part of the court expert report now. If this happens, the court has to decide what to do with the report. Whether to hand it out to the plaintiff itself, the patent holder, which would render the information obvious to the plaintiff or not. And this decision is done by a balance of interests that the court has to perform. And basically, this is done by what is the result of the inspection. Does the report discover that all the facts are given that there is actually a patent infringement or not? If the report shows the facts of a patent infringement, then in most of the cases the interest of the plaintiff to receive this piece of evidence prevails. This is also true if the defendant cannot show a trade secret at all. Then the court will hand out the report. But what happens if there's a trade secret involved and the expert report does not confirm an infringement? In this situation, the confidentiality interest of the defendant prevails and the expert report will not be handed out. Sometimes it is possible to just blacken out some parts of the report or to strike out some parts of the report, and then the modified report can be given to the plaintiff. During the inspection, the question arises: what can the defendant do? How can he defend, or what are potential countermeasures against the inspection? Well, the moment the court expert and the plaintiff's counsel appear in front of the company, they have to wait first for a couple of hours. Usually, the court set a grace period of 2 hours. In this time, the defendant can call in his own legal counsel to support him. However, 2 hours may be very short and not sufficient time for an IP attorney to arrive at the plant. Anyway, after this grace period, the inspection will start. Moreover, what the defendant could try to obtain, and I underline try to obtain, is to object against the preliminary injunction, which orders to tolerate the inspection. The problem is, however, that there's only very little time, not more than 2 hours actually, to have such an objection filed with the court, and the court to decide on that, and then the decision to be transmitted to the parties at the premises. So in practice, this happens. This does not really work, and will not succeed. But what can happen is that the defendant simply denies access to its premises. This is kind of awkward because he's ordered to tolerate the inspection, but nevertheless, unless there is a search warrant issued by the court, he must not leave anybody onto his premises. This is based on constitutional law in Germany, that you need to have an explicit search order in this regard. But this is something that the plaintiff can actually prepare and have everything ready and obtain the search warrant within a couple of hours and then enter the premises. Nevertheless, meanwhile, the defendant has gained some time. Finally, most important measure for the defendant is to observe the inspection diligently. Because, as I mentioned before, the court expert is only allowed to do what is in the inspection order and nothing more. So if he exceeds the order, then the defendant can object. What are the legal remedies against this Düsseldorf proceeding, this Düsseldorf practice? Actually, there is no appeal against the decision to grant the evidence preservation order at all. It's in the law that there is no appeal. The decision to deny, however, if the plaintiff moves for such an evidence preservation order and this motion is denied, this is subject to appeal. The preliminary injunction, which is supporting the order, however, is subject to an objection, which, as I mentioned, is not very likely to succeed within such short notice. And even if it succeeds, it mostly comes too late. So the whole discussion is going on later when it comes to the question whether the court expert report is surrendered to the plaintiff or not. This is when all this discussion over trade secrets come up. And as I mentioned, there might be a way to flatten or shorten the version and cover. So, how can this report be used once it is handed out to the plaintiff? First of all, it's a full-fledged evidence in a later proceedings on the merits, in the patent infringement proceedings. So it is used by the court ex officio, and it's full evidence. It can also be used in a different proceedings against another defendant. As evidence. Another question is whether a evidence preservation proceeding is available for court proceedings or infringement proceedings in a different country. This is a bit tricky because the competence, the venue for the German evidence preservation proceeding is the same as the main proceedings in infringement, and this would be in Germany. So it's from this procedural aspect, it would be difficult to have such a proceeding here in Germany to be used in a different country. Another question is whether the expert opinion as such can be used in a different country, but this has to be answered by the lex fori and by the law of the other country. So this said, I would like to have a look at how the system works in France, and as I mentioned, the role model of this inspection claim actually. In France, inspection orders are part of the legal system for centuries, and it was then, and in France, of course, transposed the enforcement directive into their national law as well. In fact, they didn't have to do many changes. Main feature of the saisie contrefaçon are that it's a means for gathering information. It's not a means for seizing the entire stock of the opponent, and it is no preliminary injunction as such. And very important, in the French system, there is an obligation to start proceedings on the merits after the inspection has been performed. This is not true in Germany, but in France there is this mandatory complaint on the merit. Otherwise, the result of the inspection is rendered null and void. So let's look at how it works. In France, you see from these pictures, it's very similar. However, one very important difference, the plaintiff does not have to show a likelihood of patent infringement whatsoever. The plaintiff only has to show that he has a patent and that he has actually the standing to sue. But whether or not a patent infringement takes place is up to the evidence to be obtained by the saisie contrefaçon. Well, then, on motion of the plaintiff, the presiding judge alone of the first instance court decides, not the board or the chamber. And he orders a bailiff, a huissier, and he appoints, maybe if required, also an expert. Both the bailiff and the expert are proposed by the plaintiff, and in many occasions it's actually the patent attorney of the plaintiff who is proposed and also appointed as expert. And then the judge orders either a description order, saisie description, or a seizure order, saisie réelle, which means that actually a sample of the infringing product can be seized, or a couple of separate. So after the saisie is ordered, the bailiff himself, not the court expert alone, the bailiff, he's the person who is actually leading the action, enters the premises along with the expert or any other assistant required, a locksmith or a photograph or an IT expert, whatever is needed, and the bailiff describes what he sees, process, the infringing embodiment, or seizes samples of the product, then writes his opinion, or writes his description actually of what he's found, and this is handed out to the plaintiff, usually, unless, again, at this stage, the defendant can object trade secrets. If not, the plaintiff receives the report and now has to use it for court proceedings on the merits within a period of 31 minutes. Yeah, sorry, not minutes, 31 calendars. I was looking how many minutes are there. Okay, within 30 to 31 calendar days, short period of time. If, however, the defendant objects that trade secrets are affected, then the bailiff has to sort out the part of the description which touches the trade secrets and has to give it to the court, or rather to an independent court expert who has to decide whether this information is relevant for proving patent infringement or not. If it is not relevant, then also this secret information, if it's not relevant, then it stays with the court expert because the plaintiff does not need it. If it's relevant, however, for proving the infringement, then it is handed out to the plaintiff. So he then receives the trade secrets of the defendant as well. If you look at the competences of the bailiff, you will see many similarities to the German system. He can enter the premises, describe the product or process, request copies and relevant documents, brochures, manuals, all that stuff, which supports his description, see some samples, run the process, dismantle a machine, and all measures required for the description, for the CSV contrefaçon. And again, here it is important that those measures are mentioned in the request and in the CSV itself. Legal remedies, different to the German system, the defendant can challenge the CEZ itself, saying that it was unjust, not issued in the orderly form, or maybe exceeding that the bailiff was exceeding his permissions, and by this way trying to get rid of the CEZ itself, or challenge the validity of the CEZ, of this order, in the proceedings on the merits, with the effect that once the CEZ is overtaken, the proof established by the description cannot be used in the proceedings on the merits anymore, and under French procedural law, this will lead to the fact that the claim on the merits is dismissed by the fact that the plaintiff cannot prove the infringement alone by this fact. It doesn't matter whether the product is actually infringing or not. Just the mere fact that they cannot prove it leads to the dismissal. If the judge denies the CEZ, this is subject to appeal, and this appeal, and still during this appeal proceedings, the defendant is not informed because the moment of surprise is still of relevance. And finally, the question how the result of the CEZ contrefaçon can be used. It can be used for several French proceedings, for several court proceedings on the merits in France. It can be used in foreign proceedings, at least in order to show the likelihood of an infringement for the German proceedings, for example, according to section 140C. It can be used as documentary evidence that you present the order, the report as a document, or you can interrogate the bailiff or the court or the expert as a witness. Whether it is possible to use it uniquely for foreign proceeding is still not decided on the French law. But some important lecturer voices say that it should be available for proceedings abroad. So, having said this, I come to the end, and I thank you very much for your attention.